But I guess by now, some of you I know, if I hear the word resilience one more time, I'm gonna scream, right? So I'm not gonna use the word resilience too much, but as I mentioned in the morning, the first thing I spoke, that this conference was heavily biased towards more practitioners. And typically what we tend to do is we focus on implementation and get on to the household community level work that happens. But sometimes a large scale, like a small change in a policy actually can have a very large scale impact. And, but there is a contrarian view to that as well. Some people say that even if there's a policy change, but nothing really changes on the ground, so what's the point? So we're gonna talk about implications of policy innovations for fostering the R word. So we have a very exciting group of people who are gonna speak about their experiences. I'm gonna introduce the speakers very briefly. You have a full-fledged bio in your profile, so I'm not gonna talk too much about it. But first I have Rethink Datta. He's the environmental lawyer and managing trustee of Legal Initiative for Forest and Environment, focused exclusively on environmental litigation and has supported communities, civil society groups, and affected citizens in bringing environmental issues before the court. He has authored 13 books and lots of awards on his belt. Some of them to mention was ABN AMRO Award 2007, Carl Zeiss Roll of Honor 2005, NDTV Green Hero Award, Balipura Foundation Award 2015. And so we're going to hear from them. Then we have Syed Rizwana Hassan, who's a chief executive of Bangladesh Environmental Lawyers Association, fondly known as BELA in Bangladesh. She's a lawyer of Supreme Court of Bangladesh. In professional life, she's working for the cause of environment. Received the Ononna Top 10 Award given by a reputed journal in Bangladesh, but one of the most prestigious awards she has received recently is the Ramon Magsaysay Award in 2012, and also the Goldman Environmental Prize in 2009. Celebrated. Well, I'll leave it at that. Then we have next on the line Varat Pandey, Associate Partner and Head of Financial Inclusion, Dalberg Global Development Advisors. Varat Pandey is the Associate Partner and Head of Financial Inclusion, and he's a public policy and social sector professional with experiences in ministerial advisor, multilateral institution, and strategy consulting. He has experience in governance, financial inclusion, sanitation, rural development, and climate change. Before I start my questions, I will ask each of the panelists to talk a little bit about their work and the initial questions that I asked. Does policy implications or innovations have a large-scale impact on fostering resilience? Starting with Rethink, please.
Thank you. You know, it's a fairly difficult topic to cover in few minutes, but I'll try my best. You know, it's normally, if you look at it in plain governance manner, the policy is always taken as something which is soft, in comparison to law. And though you can have a lot of policy innovations, at the end of the day, the basic issue that comes in is whether it becomes implementable at all, and whether you can actually force somebody to actually implement the provisions of a policy. It's very interesting that in around 2012, the Supreme Court of India actually ruled that though policies are there which lack the teeth or the sting, but many of the policies have the flavor of a statute. And if it has the flavor of a statute, it can actually be implemented. And a lot of policies became the foundation for subsequent enactment of law. And today, for example, two of the very important legislation where a lot of civil society action in India is actually focused when it comes to environment and rights is actually on the Forest Rights Act, which is the Scheduled Tribes and Other Forest Dwellers Recognition of Forest Rights Act, which is a very important law which recognized the right of forest dwellers. And the next very important innovation that took place was through the enactment of the National Green Tribunal Act. It was a culmination of a lot of civil society pressure that led the government to actually enact in 2010 the Green Tribunal Act. And when we look at the issue of resilience, I'll have to repeat it because it's part of the topic here, is that today, at least there is a forum where people can take environmental issues, before a dedicated court of law and a range of environmental. So issues, whether it is of climate change, whether it is of deforestation, whether it's rights of forest dwellers, today are being adjudicated at a level which is unparalleled, not only in the history of India, but also in the world itself. Today, the Green Tribunal hears close to about 200 cases every day from communities across the length and breadth of India. And I think that's really empowered a huge range of people. So you have people coming to, take on the issue of electronic waste, to mercury, to issue of radiation because of cell phone towers, to the rights to actually oppose diversion of rivers because of river linking and all. These issues have today come up. So, in a way, this would not have been possible. First, because there was some policy there, and the policy became the basis on which law was enacted, and there was civil society movement and pressure to make this system work, and that's actually worked. This month itself, on the 4th and 5th, we had an international conference of the National Green Tribunal organized along with UNEP. And what it was that about 135 judges from across the world came in and actually want to replicate the National Green Tribunal in the respective country. Why? Because it has provided an access to justice in a manner which has never been provided anywhere in the world. So I would end by stating that I think there is a good scope, but I think one must not, limit oneself to a policy, but actually take it to the next level of having a law, then an institution, and then the maximum challenge is actually making the institution work. And that needs people, it needs civil society, it needs a functional democracy to actually be there. And that's happened. But there are negative parts, but I don't think so we need to dwell with it, but maybe when the questions come. Thank you.
Assalamu alaikum. We started back in 1993, and we started as an association of lawyers. Our attitude, I would say, was very chauvinist. We would file cases, go to the High Court, win the cases, get publicity, popularize issues, blah, blah, blah. When we started, we used to go through newspapers and pick up issues. We'll then go to the field, try to find out whether the newspaper reports are based on realities, whether there are laws that can actually address these issues. Then we would take the issues to the court. When we would go to the court, I remember the attitude of the bar and the bench wasn't very friendly. I distinctly remember some senior lawyers saying, oh, the environmental lawyers have come again. They have come to waste the time of the court. And if our item was listed as number 7, and a senior lawyer had his item listed as item 8, he would stand and tell the court, my lord, this item would take longer. Can I first present my case? So they were not at all friendly to us. It was a very non-conventional subject. And the bench would also take long time because the laws that are presented before them were very new to them. I remember in the first case of Bela, the judge said, you have come before us with a law that was enacted in 1860. It's a dead law because nobody in 140 years has talked about implementation of this law. But gradually it changed. When we started getting success in some of our cases, people started coming to us. People from different parts of Bangladesh would come to us with their problems. And now we are in a stage that we don't actually have to go through newspapers to pick up issues. It is mostly the complaints that the community people bring to us about different environmental issues. Our motto actually was to take law and the judiciary to the people, people generally are very scared of the lawyers. They don't want to come to lawyers. But when they come to Bella, they always want their case to be filed next Sunday, which shows that the activism that we have done over the years have given them some confidence in the system that is encouraging them, empowering them, and that is why they don't really want to delay the process of filing the case. They want their case to be filed next Sunday. Having said that, while we were trying to translate the policy commitment into action, it hasn't been a very easy task. Because you think that you have killed a beast, but the beasts keep on coming back alive. And when there is lack of political commitment, it gets very difficult to implement policies that would actually save the interests of the common people. I give you the example of the wetland law. The wetland law was enacted back in 2000. 16 years have passed. Not a single person has been punished under the same law for filling up wetland. Does it mean there is no filling up of wetland in this country? Had that been the case, why would the government enact the law? The government has enacted the law. We are using the law to regulate the defiant real estate companies who are mercilessly filling up all our wetlands. We are winning the cases, but the next day, the government is changing the master plan, and an area that was shown as flood flow zone or wetland is being changed into housing areas, because some defiant real estate company has already filled it up. So it hasn't been an easy task, and I would describe my job as a hurdle race. I cross one hurdle, and the next hurdle is put in front of me.
Thank you, and thank you, Asif, for having us. I guess I'll just share a couple of examples from my experience of having been in the government and now seeing outside, and in the context of some resilience-enhancing initiatives that can be quite helpful. So I wanted to talk about three things quickly. One is that the role of big data and analytics in furthering resilience in our countries. And the example that I want to talk about was the example of smart maps. So smart maps are essentially maps that are different from traditional maps in the sense that they are layered with different types of maps, so that in an integrated view, you can get a sense of traffic patterns, ecological flows, et cetera, et cetera. And the value of these smart maps, which can be personalized, adapted real time, et cetera, is that they can be particularly helpful in contexts such as disasters. And as many of you know, in Chennai late last year, there was a major flood in the city, and this smart map tool called OpenStreetMap was one which was used by citizens to sort of update real-time data, to share that information, and used by citizens and responders to plan accordingly. So innovations like smart maps can be helpful both before a disaster, because you can plan in advance the kind of rescue paths, etc., that are available to you. It can be useful during a disaster, because rescue teams can track where their teams are and how the entire process can run during a disaster. And then they are helpful after a disaster, because by the fact that they are dependent on individuals to create them, they can actually be, the base maps can be updated very quickly in a matter of days rather than matter of years. So that's just an example of how an innovation using big data and analytics in today's context can actually help our resilience. And I think that the policy implication here for governments is that it's not something governments need to make large investments in. It's something that they need to facilitate. And they need to facilitate by having an open and liberal mapping policy. Very often governments take the issue of national security as a reason why they cannot have liberal mapping policies. But I think examples like this show that actually there is significant value in doing so. The second thing governments should do is to encourage citizens to engage in platforms like this. So that was, big data. I think the second is thinking about innovative institutions for resilience. And I wanted to go back to one of the things we discussed, Asif, in your session earlier in the morning, which was this idea of a global program called the 100 Resilient Cities, where we've been working closely with, where the idea really is that resilience is such a cross-cutting, multi-stakeholder issue that it's not going to be solved by any one entity or any one department in government or any one set of stakeholders. So can we make this a citywide initiative where we appoint a chief resilience officer for a city, whose mandate then is to bring together different stakeholders in the city, develop a citywide resilience agenda, and then work full-time for 3 to 5 years directly with the mayor or the municipal commissioner to actually implement what has been collectively agreed. And again, this is an interesting example because once again, the cost, the incremental cost associated with putting in place such an institutional innovation is actually very limited. All it costs is the salary of a chief resilience officer who has to put this together. But it can get you tremendous return on investment in terms of your resilience outcomes. So I think that's another sort of policy lens that is helpful to keep in mind. And thirdly, I wanted to just briefly talk about how one can embed resilience in government programs themselves. And the example I want to talk about is in India, as many of you know, there's a program called the Mahatma Gandhi National Rural Employment Guarantee Program called Mahatma Gandhi Narega, which is essentially a program that is trying to do two things. It's trying to give 100 days of employment to one member of each rural household on a demand-driven basis, and use that to create some local durable assets that can be helpful for the community. And so I think the innovation, the policy innovation there is that in the design of the program itself, the type of works which have been proposed are the ones that enhance resilience. So almost 60 to 70% of the works under Narega are things like drought proofing, flood proofing, land improvement, silting of ponds, afforestation, coastal improvement, local irrigation, etc., which are all extremely strong resilience-enhancing innovations. So there, I think the takeaway for policy is, one, embed resilience in the design of policies themselves, and B, as far as possible, make these policies bottom-up, demand-driven. So in Narega, the big feature, of course, is that the decision of what kind of works take place are actually done by the community, by the Gram Sabha, which is the local unit of governance, which decides to sort of prioritize those investments. So basically, I wanted to say that there are three interesting areas that we should keep in mind: big data analytics, innovative institution building, and designing resilience within government programs. There are important lessons for policymakers on how, through very limited investments, through very limited financial outlays, additional financial outlays, they can get tremendous return on investment for resilience.
Thank you, Bharat. The next question is actually for you, because I want to come back from that way. Because you also have previously worked as a special advisor to India's Minister for Rural Development. Rethink and Rizwana has mentioned that political commitment is a key thing. But having worked inside the government, and those three things you mentioned is a fantastic initiative for generating evidence. But give us some inside info on how government works and doesn't work, and also some difficult issues like deforestation and all these environment issues that they mentioned.
Yeah, so firstly, having spent 5 years in government, I think we often have a tendency of blaming government and saying government is either ineffective or corrupt or not really interested in people's welfare and so on. I think it's also important to recognize the flip side, which is that government functions within its own constraints. There are, of course, very large capacity constraints in governments in developing countries. So, for example, one of the things I realized is that even a very willing and able and dedicated minister has very limited ability to actually get transformative change done, because he or she is relying on the team that is given to him. And in our countries, we have a career civil service bureaucracy, which is very difficult to sort of change. There are limitations in terms of bringing specialists into senior positions in governments and so on. So there are legitimate constraints that governments face. And I think, for me, what I learned was that effective policy making in government requires three things. One, of course, is there should be a technically robust policy proposal, which, of course, is sort of a necessary condition for good policy making. But that by itself is not going to get you effective policy. So that's the first thing, but not the only thing. The second, of course, is it should be a politically feasible policy. So it should be you should have thought through a way in which you are going to either align a large number of stakeholders around it, or you're able to somehow neutralize those who are not going to be in favor of it. So I think that's sort of the second condition. And then the third is it should also be administratively implementable. So given the system of public administration, the system of last mile delivery in a country, is it something that is, very interesting and very, theoretically very sound, but is it actually going to succeed on the ground? So I think these are the three filters one should always put when thinking about from policy to actual action. And I think, Rethink and I have worked together on some work earlier when I was in government, which is the National Green Tribunal Act, which Rethink talked about. I think that was a great example of something which was, technically robust. People like Rethink and others worked to convince the political establishment how it is politically feasible. And then also the mechanics of it, how do you put together a tribunal that has the right kind of skill sets, which brings both judges, traditional judges, but also sector experts, which again is another innovation of the NGT. So I think the lesson for all of us who are not in government is really to think about how do we package what we want to get done in the context of these three elements.
My question next, it's on the flip side. Then he's saying sometimes it's capacity constraints, sometimes it's not enough implementable proposals that come in. What would you say to that? And at the same time, what is your strategy in terms of actually making things happen?
It actually depends on the system in which you operate. When I read the Indian laws and then I compare them with the Bangladeshi laws, the feeling that I get is the Indian lawmakers actually try to address the core problem. On the other hand, increasingly, our lawmakers move around the core problem, address the side issues, and do not really get into the core problem. So politics in different countries differ. There are laws that are common both in India and in Bangladesh. For example, the Forest Act of 1927. It's a common piece of law. Subsequent to that, Indian government has enacted the Forest Conservation Act 1980, because the 1927 law does not talk about the responsibility of the Forest Department to conserve the forest in its natural state. Bangladesh government hasn't done anything of that sort, despite repeated appeals from the civil society. Because the forest bureaucracy is very comfortable with the power that the colonial rulers have given to them. Rethink has talked about the National Green Tribunal Act of India. Bangladesh was probably one of the first countries of the world to have the Environment Court Act. That was back in 2000. But that again is revolving around the problem and not addressing the problem. You have made a court and you are saying the court would enforce the Environment Conservation Act and such other act as may be notified subsequently as environmental law. No such subsequent notification has ever come. So you have the court system, but it's not functional. I would say that in the governance in which we operate, our public agencies are either non-functional or malfunctional. In the case of India, they are either functional or semi-functional. I mean, nobody has a foolproof system, nobody has a perfect system, but our race of perfection and the degree of expectation is actually really lagging behind because the political commitment is totally missing. I've given you the example of the wetland law. How can there be no punishment under the law? When you have enacted the law in 2000, you definitely knew that there are cases where people are filling up wetlands, but then you haven't managed to punish one single offender. That's not the case in India. When I ask for information under the Right to Information Act, sometimes the government agencies take 1.5 years to respond to my answer. They give this ground, this plea, that plea, so that I can't even file an appeal. After 1.5 years, when they give me the information, the forest is gone, or the wetlands is filled up. So if you have manpower to delay the process for 1.5 years, can the same person not deliver the information? I'm sure they can, but what is missing there is political commitment.
Thank you. So, Rithik, I recently read an article in the Economic Times that where you were described as a perennial nuisance to India Incorporated. You and your partners brought about 70 cases per year to the Indian Supreme Court against the semi-functional government of India, I guess. So, do you find that India has the legal framework to protect the people and the planet against big corporations?
You know, it's, when Economic Times did this story, you know, that's one problem that I face on a daily basis. And it's a kind of a discrimination because as an environmental lawyer, when you go before the court, you know, you have about 8-10 cases and you stand up saying, you know, I'm representing against this particular dam, this particular mine, against this particular road. And the judge will ask you, why are you opposing all the projects? Don't you have any other job? You know, why are you saying no to everything? And it's very interesting that the same judge, you know, will never ask a criminal lawyer who's representing 10 different murder cases, why have you committed so many murders? You know, that never happens. You know, that fellow who represents every tax violator is seen as a successful lawyer. And an environmental lawyer, as Rizwana was saying, you know, are seen as hurdles. Now, we are representing people. And I think to answer one of your point, I think thanks to, you know, the National Green Tribunal Act, which got passed in 2010, we actually have a very unique system. And I always say that, you know, with those who drafted it, excellent. But I think a lot of parliamentarians did not read it properly. And if they've read it, they wouldn't have. Because many a times they say, what is stopping India from becoming China? They say it's National Green Tribunal. And why? They say that because, you know, it's a very important part that has been given that the act actually empowers and gives power to any person to actually come before the tribunal to oppose any project. Now that is an extraordinary power which has not been given in anywhere in the world. You know, so any person aggrieved has the right. So first and foremost, it doesn't insist on you to be an affected person, an aggrieved person. You can be anybody in this world to actually challenge a project. That's number one. Number two, that redressal is given, but at the same time, you know, very recently the minister said, you know, the environment minister, that every decision of mine is challenged before the Green Tribunal, and the tribunal actually interferes. It's not a fact. You know, the number of projects that are approved is so many, but a misconception has been created that everything has been challenged. But nonetheless, I think we have been able to get success which may not have been possible in many other parts of the world. For example, the single largest direct foreign investment in the history of India, POSCO, the Korean company, was actually stopped by the Green Tribunal on the ground that it will affect the livelihood of the people and it will affect the turtles. Now that's something which is not possible in even the Western world. Vedanta, which is a very classic case, where the UK-based company was stopped from mining it. So far as, you know, the avenues are concerned, it is there. Nonetheless, there are other type of constraints which still come in, like access to justice may still be problematic because of financial and other reasons. It can be an issue of distance. It can be an issue of time. You know, you have to come before the court within a certain stipulated time. If you have missed it, you have missed the particular one. But just to point it out, I think the avenues that have been created to address the justice is good, right? I think it just needs more awareness among people to actually approach it in more numbers. Today, for example, just to say, roughly about, anything between 30 to 40,000 approvals are given by the ministry and the state environmental impact assessment authorities at the state level. You know, mining, dams, roads. Out of that 40 to 50,000 approvals, 30 to 50,000 approvals, only about 100 are actually challenged in the court of law. Out of that 100, only about 6 or 8 get stopped finally. But then because of the 6 that get stopped, the publicity is such that an impression is created that within the corporates that, we would have transformed the country but for these environmental lawyers and the laws and the communities, which is a complete misconception and a wrong idea that has been perpetuated. And a lot of our effort, even as lawyers actually go, in order to actually educate the media that, what has been said is actually not correct. And let's look at the real facts. So that's what I would say.
I was just going to say, people like Rethink are not only a nuisance to India Inc., but also to the government, which I think is a great thing, because I think we need that pressure to hold the government accountable on things that it is trying to create and it is trying to do. Just one point I wanted to make, just following up to you, I think there's a tendency, I don't know how much it is in Bangladesh, but in many developing countries now, to enact more laws, right? Because the rights-based legislation discourse and other things. Laws are important because they give people, entitlements to things that are really fundamental. But I think often what laws don't do, and should do a lot more of, is to also correspondingly say what kind of capacity will be required to actually implement that law. Otherwise, the gap between our laws and the implementation just keeps widening. So I think NGT, for example, was very clear in terms of, we need 20 members or thereabouts, 10 which are judicial members, 10 which are expert members, and that's the minimum that will be required for this to even have a chance to succeed. And I don't think a lot of the laws that we pass does enough thinking around the capacity that will be required, both the judicial capacity and the implementation capacity that will be required. The Right to Information Act, for example, which has been enacted in many countries, was just enacted, and then I think civil service bureaucracies, which are already overloaded, were often, had to add another function in their 100 other things to do. And that meant, X% of time of that ministry now goes in replying to RTI queries, which means that the time available to do other things comes drastically down. So when we think about legislation and policy making, we often ignore what is required to make it succeed, which I think we should be paying a lot more attention to.
On that note, but then if we wait for the system to be ready to respond, they will always use that as an excuse for not enacting law. So if you first want the bureaucracy to be ready to respond to all your queries and then have the right to information law, you probably will never get a right to information law in Bangladesh. On the other hand, if you take a policy of proactively disclosing your information, your officers don't need to be overburdened. And we will not be asking for information from you if everything is available on the website.
Just a last follow-up question for you, which is that you also mentioned that this people are now more aware of the law. They are coming to you with their cases. So how do you pair up with implementers to raise this awareness? And what is the silver lining for you in spite of all the dysfunctionalities?
See, it's like having a law that actually gives you some strength to fight for your case. Similarly, when you have a court order in hand, initially we used to think that we have got it. We have won the case, but that is not at all the case. Then starts the second phase of your struggle. You have to really start working for getting it implemented, because in most of the environmental cases, your opponents are very powerful. They're politically linked up. They're moneyed people. They can purchase up the whole system. So their strength and the strengths of the communities who are affected cannot simply be compared. So one strategy is to engage with the community, keep them engaged in the issue. Sometimes issues come from remote places of Bangladesh. For us, sitting here in Dhaka, it's actually impossible to follow up. So if the communities take regular interest and they keep on informing us, it's easy for us to do the legal follow-up. But then we also have to engage with the policymakers. For example, in the shipbreaking case, the court wanted the government to draft rules. The government took 2.5 years to draft rules, and the government only submitted the rules when the court says, if you don't submit the rule by, it says the 15th of December, we'll shut down the industry again. So then 2 different ministries of the government submitted 2 different sets of rules on the same subject. And both the rules were Gazette notified. And they are based on totally different premises, have totally different institutional setup. There you can clearly say that the government is not at all in the mood of regulating the industry. And then when we were regularly following it up with the judiciary and we were telling the policymakers that this is where you have actually deviated from the directions of the court in framing the rule, a third ministry emerged in the scene, and the third ministry is now drafting a law on shipbreaking. And that law is not at all regulatory, which was the spirit of the judgment of the High Court. It is rather facilitative, and it says, since it is important to promote the shipbreaking industry in Bangladesh. So you see, in a situation like this, how do I work for implementation of the judgment, or how do I work for implementing the legal framework is not easy to answer. Finding the silver lining is very difficult. In this particular cases, we have engaged the international actors who are actually sending their ships to Bangladesh. We are taking up an application to the court every time a worker is dying. So it's regular follow-up, it's using the media, keeping the issue alive, even if the government is not at all interested, or the government's interest lies elsewhere. You have to keep the issue alive, and that's what we do.
I just wanted to, since there are two strong activist lawyers here, I wanted to ask you, because I know that more than 50% or something, I've read, backlog of cases in the courts arise because of government as a litigant, either as a defendant or as a, and then also a large share of them is because there are different government departments that are litigating with each other. Is it not possible for the courts, for the Supreme Courts, to say that whenever a government comes to the court, it should come with a common view on a position? Because that would almost force the executive to make those hard decisions themselves, rather than forcing it on the courts to make a decision.
The thing is, I certainly don't want the Ministry of Industry and the Ministry of Environment taking the same view on an issue. I want if there is difference of opinion, I would rather hope that the Ministry of Environment actually holds on to its position, because its mandate is to protect environment, whereas the mandate of the other ministry is to promote environment and not really to look into the environment issue. Although the laws actually require both of them to be protective of environment. I don't think the backlogs are actually caused because the government agencies take different stand. In Bangladesh, the backlog is due to the fact that we have less number of judges than are required. Lawyers are reluctant to pursue case. If I get a stay order or an injunction, I don't want the case to be heard finally because I may not win. The lawyers are also overburdened. In environmental cases, we do not have enough number of qualified lawyers. If you ask me how many environmental lawyers you have in the country, I can immediately give you the number and the names. I'm sure that's the case with Rethink. We do not have that many lawyers to actually regularly pursue the environmental cases.
It's, the government is the major litigant, and I think what is needed is the government to actually rethink on every single litigation it does. I can just share one example of a case about 3 years back where the Green Tribunal actually imposed a cost of 25,000 rupees on the Secretary Environment to be paid obviously by the government, right, as cost for, it was a matter relating to a national park, Kaziranga, where the government failed to do certain protection work. And they imposed a cost of 25,000 rupees on the Ministry of Environment and Forest. The Ministry of Environment and Forest went in appeal against the decision and continued with the litigation for about 2.5 years. And it ultimately, which we had got under the right to information, spent 17 lakh rupees, right, in order to ensure that it does not pay 25,000 rupees. So that's the kind of, and this is not just one example. There are numerous cases where, principally because the officer does not want to take the liability, the litigation goes. So there is a huge nexus among officials and the lawyer community also, because they are the beneficiary of that amount that comes in, who give wrong legal advice, go to the Supreme Court and actually clog the entire judicial process. And I think it needs everybody to come together, to expose these kind of things.
Absolutely. I mean, kudos to both of you that even if you are the nuisance of the government and the corporates, you are heroes to the citizens. I think everybody will agree to that.